And during the proceedings of 30 January 2024, line 10 to 15, Advocate Mnisi says, despite the fact that there are those records that have been made available, the disc and the record of the transcript, quote, but we have read those, and Advocate Mnisi says, I have read them, they have been handed to us now. So it's just a confirmation, my lord, that we did bring that to the attention of our colleagues. But there's just that one portion which of Exhibit EE, which we want to put in record, and this is the proceedings of 27 October 20.
I'm going to object, my lords, to this so very unknown procedure. The issue, my lord, in this application, or the issues in this application, are specifically defined. There's been an application by accused number 4 that on the basis of the fact that the state has not been able to establish a prima facie case against him on all the counts, he requested the court that he should therefore be discharged at the close of the state's case. The state's response, the manner in which they've responded, that is the issue that needs to be determined at this point in time. Now the state stands up, and it is struggling. It's very struggling. He stands up and say, no, but there's a Makaleni issue. There's the record of the transcript, my lord. What do those submissions have to do with the application that is so circumscribed, that is so specific? And I've indicated on Tuesday, my lord, that the state, if it feels like there is something that they have missed in the presentation of their evidence, which I would refer to as struggling, they would still have the opportunity. There is nothing wrong in terms of the procedure for them to stand up and say, my lord, we acknowledge the fact that we had already closed our case. But there is information that we feel, in our view, that would be the state saying that we can use at the end of the state, at the end of the close of the case, to make an argument that will supplement our application for a conviction. Then the court will have to make a decision on whether or not it grants them that leverage or that allowance or that indulgence. But not now, my lord. Because if I were to stand up and start to address the issues that the state is now raising, this procedure will be very precarious. It will be unheard of in any civilized legal system, particularly in a system that is codified. And ours in South Africa is codified in terms of this Criminal Procedure Act number 51 of 1977. Such procedure is not allowed, my lord, particularly when there's an application in terms of section 174. This section must be dealt with and be finalized. Then the state, as I've said, if they feel there is something that they need to add into their struggling evidence, then they can stand up and say, no, we also want to add this another struggling point in our struggling evidence through an application. The state does not even apply now. It simply says, we also want to add this, we also want to add this into the record. What is the purpose of this sitting, my lord? Is it to introduce new evidence or to make a determination on whether or not accused number 4 has been able to bring to the court an argument which in the mind of the court says that it should be discharged, or the state which in the mind of the court says accused has not been able to discharge the honors in terms of section 174. Those are the issues at this point in time, my lord. Otherwise, the procedure that is being followed here Fiasco does not even begin to explain it, my lord. It's unheard of.
Yeah, fine. I've heard you. You see, the problem with you and your colleague arguing, you discuss things in my absence, and then you want me to solve them. You see, he says, you approached him. I wasn't there.
No.
And you complained about A, B, C, D, E, F, G.
No.
And now he says he's rectifying what you complained about. Am I correct, sir?
It happened in court on Monday, as he says. That's why they said.
Now I'm being blamed for not knowing the procedure.
Yes.
No, my lord. I am not saying the court does not know the procedure. But what I'm saying is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord. Now, the issue is, my lord, there are issues which have been raised here. And the procedure at which we are now, which is an application in terms of section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence.
Okay, so are we...
Through the back door, my lord. Well, I don't know if this procedure, if the court really affirms this procedure, I'm in the hands of the court.
Don't talk about the procedure, because I'm telling you what you do in my absence.
No, but my lord, there was no agreement. There's no agreement that we've...
But you spoke to him.
About what, my lord? We spoke to him about what?
Okay, fine. That's it.
I never speak to the state, my lord, because I know the way in which they operate. Everything that I do, I make it a point that it is done on record. I know the way in which they operate.
As we pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions. We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We're putting on record what ought to be considered. I don't understand the objection by my learned friend. Nothing, no new application. We're just saying the court, as we've done, we have summarized the evidence. These are aspects that we could have mentioned in the summary for evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary. Nothing new, my lord.
Okay, is that the end of the argument?
Yes. So
what do we do?
Yes. I think Advocate Ngumalo wanted to respond to the state's submissions.